Good afternoon. My name is Franklin Alvarez. I am the Assistant Vice President of Business Development and Entrepreneurship at Invest Newark. Thank you for joining us today for Small Business Law 101, Real Estate Edition. Today's webinar marks the first event in an ongoing series of small business law trainings that Invest Newark will be hosting. Please visit our website at investnewark.org and subscribe to our newsletter for further information about our upcoming events as well as business opportunities. Today's session will be hosted by Alana Miles, a Newark-based real estate attorney and the founder of Miles Law, LLC. In today's presentation, Alana will help us navigate the ins and outs of leasing and purchasing commercial real estate. And now I'll hand it off to Alana. Thank you.
Thank you, Invest Newark, for having me. I am going to share my screen once I get the permission to do so. All right, so let's jump right in. Commercial real estate law, leasing and purchasing. Before I go any further, I will let you know that I am not purporting, while I am an attorney, I'm not purporting to represent anybody that's watching this webinar, and neither is Invest Newark. However, I will give you a lot of helpful information on leasing and purchasing from a lawyer's perspective, okay? So let's jump right in. All right, so what is commercial real estate? Commercial real estate is property that is used exclusively for business-related purposes or to provide a workspace rather than as a living space, which would instead constitute residential real estate. Most often, commercial real estate is leased to tenants to conduct income-generating activities. Examples of commercial real estate could be a retail space, industrial property, vacant lots, apartment buildings, warehouses, office buildings, and multifamily developments. In our presentation today, we'll talk a bit about a little bit of each. So if you're interested in either, you will have some good nuggets to hold on to. Okay. All right, so let's talk about the law. Commercial real estate law regulates the sale and transfer of properties for business use, okay? So not for residential use, it's for business use only, and that will have to be detailed in whatever agreements you have. Commercial real estate law also includes other issues such as leasing, property and land use, liquor license, and zoning issues. For the purposes of tonight's presentation, we will be strictly focusing on leasing and sales. We'll talk a bit about land use because you'll have to detail how you're using your property. And I'll talk a slight bit about zoning issues if we have time, okay? Feel free to jump in if you have any questions. You can jump in the Q&A chat and ask those, and then I'll also be taking a couple of breaks to get any questions that we may have, okay? All right, so commercial leasing. Let's get right on over to commercial lease. I will be showing you a commercial lease, and then I'll go through important sections that you should know in a lease. But as you can see to my right, that is a example. All right, let's go. All right, so this is a commercial lease with options to renew. So when you have a commercial lease, you want to first note whether your lease has an option to renew or whether it's just a lease for a certain term. The reason why this is important because your option to renew section is going to tell you whether you have the option to continue on the term, and depending on your project, if you have a salon, for example, and you want to have some longevity in the neighborhood, you want to have an option to renew. But let's first talk about the standards. So your standards are always going to have an agreement date. You should always date any contract or lease agreement that you have. You should always date it and then include who it's by. So your seller, in most instances, your seller will be an LLC. Yourself may also be an LLC. And while you'll sign as your LLC, you also want to know who that individual is or who is authorized to sign on behalf of you or your LLC. Okay. Then obviously you'll include the premises, which is the address of the property that you will be leasing. Okay, term. So this is an important section and it corresponds with the option to renew. So So for example, say the initial term is 3 years. You want to always have a start date for when that term is going to begin, and it's likely not going to be the date that you sign the contract. In a lot of instances, it may be a month after you sign the contract, because you'll have an opportunity to do what's called due diligence, and we'll talk about that in a bit, okay? So say you have a 3-year lease term for an initial term of 3 years, and it'll end January 31st, 2024, if it starts this year. Note that if it is a 3-year lease, some sellers may draft it to be 3 years from the date that you sign, or some sellers may draft it to be 3 years from 3 years from the date that's the end of the year, if that makes sense. So here you'll see that the date is January 31st, 2024, which they count as a 12-month period versus it being February 15th, 2024. That's just a nugget that you can hold on to. But I like when I draft, I like it to be 3 years from the date of commencement. All right. Because this isn't an option to renew, you'll always see when your term is to extend the lease. Okay. This is a 3-year term or 3 extension term, which means that you'll have 2 additional times to extend the lease for another 3 years. Each term is going to have an increased amount in rent, but we'll talk about that in a bit. But you want to specify that. If you want more than 2 terms, it's standard to see 3. If you want more than 2, talk to your attorney about getting that in there, and then talk about how you would want to extend. If you do have an option to renew lease, even with an additional term section, you want to make sure you're not binding yourself. Okay, so what that means is, although you may agree to extend the term, you don't want to say that you will indefinitely agree to extend it, which means you don't want your lease to automatically extend after that 3-year period. Say, for example, I don't know, maybe you expand and you need a bigger space. You don't want to be locked into those terms. So you want to always have an option to get out of it, and not have to extend. And you also want to make sure that there's a date period that you have in order to get out or extend. Okay. All right. The next section is the use. This is an important section because your landlord is going to restrict your use, but you want to make sure that if it's that the use of the property coincides with how you want to use your business. So say, for example, this is a cosmetology, they're doing cosmetology services. Say it's a spa, for example, and you want to be able to play music. There may be a section, an additional term section in the contract that says no music is allowed, or there's zoning ordinances in the neighborhood where you can't play music. And if it's a spa, you may not agree to that because your clients may need light music while they're getting massages or whatever. Okay. Rent. Okay. So the rental section is also an important section, especially in an option to renew, because you want to be able to determine how much your rent is going to increase for every term. Here in this contract, they're doing lease year by every year in a term. You should talk to your attorney about whether that's a good option or not. When I'm representing my clients, I like for it to be a flat rate for all 3 years in a term. But a lot of times a landlord's attorney will want to increase the rent yearly based off of standards. Okay. All right, let's jump down, and I'm only going to tell you like important sections of the lease, but let's jump down to repairs and care, because this is an important section. The reason why it's important is because your landlord is probably going to require a deposit. And somewhere in your contract is going to say that you're going to be responsible for repairs and maybe maintenance. So you want to make sure that the property is in the best condition as possible. It's likely that when you lease a property, it's going to be as is, which means that the landlord may not agree to make any repairs. However, since you're taking on this leasehold, you want to make sure that you at least know what those repairs are. So I'll just read the paragraph to you, and then we'll talk a bit about what it means, okay? So the tenant has examined the premise and has entered into this lease without any representation on the part of the landlord as to the condition thereof. The tenant accepts the premises in its as-is condition, including but not limited to the condition and capacity of its existing electrical, plumbing, and HVAC systems. The tenant will take good care of the premises and will, at the tenant's own cost and expense, make all reasonable and necessary repairs to all non-structural components of the premises. Tenant will maintain the premises in condition, in good condition, and state of repair, and at the end of or earlier expiration of the term, and will deliver the premises in good order and condition. Wear and tear from reasonable use is accepted, and damage by the elements not resulting from the neglect or fault of the tenant is also accepted. Okay, so the reason why this is an important paragraph, because you need to know what obligations the landlord is going to have from you, okay? I always recommend that my clients get an inspection. Although you're not purchasing this property, I always recommend that my clients get an inspection before agreeing to a leasehold, especially if you're agreeing to maintenance and repairs. Because say, for example, you have a salon and there's plumbing issues. You're going to be using sinks a lot. Your clients may need to use the bathroom. You don't want to deal with plumbing issues, and you ultimately don't want the responsibility to be on you if there are plumbing issues that will require routine maintenance. Okay. Alterations and improvements. This is a really important section, especially for our clients who may have a retail space, for example, and you want the space to look a certain way. So alterations and improvements, in this paragraph, it's really going to encompass how you can use the property, anything that you do to the property. So say you do renovations, maybe you want the floor to look a certain way, maybe you're installing sinks for a salon. If you are leasing out a space for a chain restaurant that has to look a certain way, you're going to be responsible for all the alterations and improvements to the property. You want to highlight this section and see what you will absolutely be responsible for, because ultimately when you end your lease term, you may or may not be responsible for turning the property back into the condition that it was in. And it's likely the case that you will be responsible. So you want to note that. However, you also want to know if you will be allowed to remove what you've constructed. So say you wanted to install new flooring. That now becomes a fixture to the property. So a fixture to the property means that it's attached to the property and you can't remove it from the property without changing it or without changing its value. So it's likely that will likely be a term in the contract that says you can't make those changes. So you want to note that, especially if you have expectations of removing it when you leave. Okay. Okay, signs. Okay. So paragraph 7 is on signs. This is another important section that you may want to note, especially if you have a visible sign that's outside. You want to make sure that you consult with your attorney to ask about if there are any municipal ordinances or zoning, any zoning laws, or not necessarily zoning laws, but definitely municipal ordinances that will restrict your use of signs. So maybe you want to put a sign on the street and the municipality doesn't allow street signs because pedestrians need to walk. Or maybe you want to put a sign on the roof, but the sign has to be a certain size. You want to make sure that this is a term that you go over in detail with your attorney if you will be using signs, to make sure that you legally you can do so. Okay. All right, and then the next section is on utilities. This is also an important section. Don't gloss over it, because it'll say whether you're responsible for utilities or not. Most often than not, you're going to be responsible for utilities. If you're not, it'll be included. But if it is included, you want to make sure that it's capped. If the landlord is agreeing to be responsible for the utilities, it's likely that there is a cap on there. So you want to note what that cap is and get an estimate of what the costs are. So I don't know, say the cap is $300 a month, however, you know that it's likely supposed to be like $700. You're going to be responsible for that $400. So you want to make sure that you are doing your due diligence on that part. All right, paragraphs 11 and 12 are on insurance. I highlighted them, but I'm going to just briefly talk about them. It's really important. Get insurance. That's the main line. I don't do insurance, so I can't tell you where to go, but you want to talk to your attorney and make sure you get liability insurance. You also want to make sure you get hazard insurance because it protects you, your property, and your ultimately when you have clients, if anything happens, you want to make sure you're covered. Most policies require that you pull out a policy of at least $1 million. So make sure you're just shopping around for the best. Okay. All right, and then this inspection and repair section goes in hand, in part to what we talked about earlier regarding what your responsibilities are and whether you will be responsible for maintenance and repairs. The inspection and repair section tells you whether or not you have an opportunity to do inspections. If you have a commercial lease that says that you are not allowed to do an inspection, talk to your attorney about whether you should go forward with the lease term or not. Okay. Right to exhibit. So this is a key paragraph. This is a key paragraph in a lease contract that has the option to renew. The right to exhibit means that the landlord, it's the landlord basically asking for the right to show the property to potential buyers if they want to put it on the market. The reason why this is an important paragraph, because you want to talk to your attorney about whether you want to give that right or not, and when you want to do it, and how much notice you want. In addition, whether you would want the option, the what we call the right of first refusal, which means that you'll have the option to purchase it before anyone else. The reason why that's important is because you don't want to get into a lease. You spent a lot of money getting the place up to, up to the design that you want, and then you find out that your landlord is selling the property. So this is a really important paragraph that you should always know. All right, and I see there's a couple of questions in the chat. Once I go over the lease term in full, I'll stop for questions before we go into transactions, purchasing transactions. All right, and the next important paragraph to note is non-liability of landlords. So what is your landlord going to be responsible for, and ultimately what won't they agree to be responsible for? The reason why this is important is because a lot of times this section will tell you what the condition is of the property without even doing inspections. This paragraph is very, like how I've drafted it, it's very vague, so it kind of covers everything. And a lot of commercial leases, though, you'll see specifics. So landlord will be responsible or won't be responsible for any injuries that may take place, specifically if it involves plumbing. Then you should talk to your attorney, because they'll probably note, hey, you should probably get an inspection to see if there are issues with the plumbing. Ultimately, the reason why a landlord is going to include this, they're going to want to be indemnified because you have insurance. So if you have a salon, for example, maybe your chairs are in the way, someone slips, they don't want to be liable. They don't want to be liable for your guests. Okay, now let's jump down to non-performance by the landlord. So non-performance by the landlord, what does that mean? Really what this means is what happens if the landlord stops doing what you ask them of them? Do you still have to pay rent? The short answer is yes, you should. Yes, you should, but you should also consult your attorney about what options you may have. The landlord is still going to have obligations. Their obligations are going to be whatever the obligations are that's set forth in the agreement. So maybe it's routine maintenance, it may be paying the utilities, etc. However, as tenant, you still have an obligation to pay, which would be paying you paying your rent. Okay. All right. All right, so now we're getting into that option to renew section. So we talked about it briefly when we started, but if you have an option to renew contract, you should always have a paragraph that's explicitly solely on the option to renew. It should detail your terms. So for purposes of this contract, it's a 2-period extension for 3 years each. Each period, your rent is going to be increased by 3%. Note that I said period though, not years. You wanna highlight that, and it's really important to note that, because sometimes a tenant may not realize that the landlord will also try to increase the rent by year and then increase it after that by period. So that's something to really take note of, and talk to your attorney to make sure that that's noted in detail. Okay. And this is a commercial lease. Make sure you sign it. Make sure you date it. If you're an LLC, you want to make sure that you're signing with your name, so that it's traced, and also always date it, because the date that you sign, even though at the top it says this agreement is made on, that won't be the date that you start. All your start dates are going to start from the date that you sign. Okay. Are there any questions? Let's go to the chat. Do I need an architect or interior designer before I have a lease? Do I need to have the landlord approve these designs? That's a really good question. Depending on your use of the property, it may be beneficial to have an architect or an engineer designer come in before. You should always do that though before signing anything, especially if you have an architect that's not going to recommend the space because they can't accomplish your goals. So before you do that though, you always have to get approval. It's likely that you'll be working with an agent. So you want to make sure that the landlord will approve you bringing in other professionals to kind of inspect the premises before going into the lease. I always encourage my clients to do everything at once. So if you're going in to do an inspection, you may also want to bring in an architect. You may also want to bring in an interior design to just make sure your vision can be accomplished before signing any documents. Because once you sign the documents, you're going to you should uphold your obligations. And does your landlord have to approve the designs? It depends on what the contract says. Most instances, it may be vague. They may say you are going to be responsible for your contractors. So any agreements that you take out, you have to be responsible for paying them. If you don't pay them, they can't put liens on the property. So the liabilities will go directly to you. Can the landlord sell the property while I still have a lease? All right, so that's a great question. Let's jump back up to right to exhibit. So the right to exhibit section answers that for you, and they'll tell you whether or not the landlord could still sell the property while you have a lease. You want to make sure, especially if you plan on being in this space for a long time, this is the section where you want to talk to your attorney about protecting you the most, to make sure that either one, you have the right to purchase the property, or that they can't sell it while you're in maybe your first period. Okay. Okay, next question. If the apartment above the storefront has a leak that is dripping into my shop and destroys my inventory, the landlord is not responsible. That's another great question. So this commercial contract is for a property that is separate and apart. So when I say separate and apart, that means that there are no attachments to it. So there's not a house. If there was a house connected to it, an apartment above, that's what we call a mixed use property. You would also have a paragraph in your agreement that talks about that. Ultimately, the landlord will be responsible for that. You should only be responsible for repairs in the commercial space, if that's what's agreed to. But since you asked a question about mixed use property, you want to make sure that there is a paragraph about that protects you too. That's a great question. All right, next question. When should I get a real estate attorney? What are the usual fees for lease review? You should get a real estate attorney before signing anything. Most often what's going to happen is you're going to get an agent first, and they're going to show you around. Once they show you around, you'll get a contract. Once they give you the contract, you should go go through it with your attorney and retain an attorney. As far as the fees vary. So I can't speak to that. It really depends on how in depth your attorney is going and how they charge. So some attorneys charge flat fees, and it may be a fee of $500 depending on how in depth the space is and how detailed the agreement is. Some attorneys may charge by hour, which means that they're going to charge you an hourly rate to review, and then we call review and revise, which is really kind of drafting or annotating sections in the contract before allowing you to approve it. All right, what's a letter of intent, and do I need an attorney for that? So we're going to talk about purchasing next, and I'll talk about the letter of intent then. What if I want to share the space with another business? Is that possible? Do we sign separate leases? So your agreement is always going to be between yourself and the landlord. You want to see if there's a section that allows you to sublet or not. If it does allow you to sublet, I'm pretty sure that for commercial purposes, there's going to be a section in there where the landlord is ultimately going to hold you responsible. As far as sharing the spaces with multiple businesses, say for example, there is a commercial space where one business has a nail salon and the other business has a hair salon, and you guys want to share the space together. The contract will just say between landlord and tenant 1, tenant 2, and you'll have your information in there. Okay. But I would still recommend that both parties get their own attorney for their own protections. All right, and then how do you break the lease? It depends. It depends on the reason that you want to break the lease. So I would answer that question by saying consult your attorney, because every situation is different. So you would really want to just consult your attorney on breaking your lease. Okay, so we're going to jump back into the presentation. I'm going to take a pause from questioning, and let's move right along. All righty. All right, we talked about commercial leasing. Now let's talk about commercial purchasing. So commercial purchasing is a bit different than purchasing residential real estate. While in residential real estate, oftentimes you'll see what's called a standard contract of sale, which means that that's a contract that a real estate agent can draft on your behalf and can submit it. You can sign with or without an attorney. With commercial purchasing, however, an agent cannot draft the contract. What they draft is what's called a letter of intent that kind of includes all the details that you want to the terms or the agreement to be governed by, right? And then you must get an attorney, and your attorney has to draft it. We'll talk about that, and we'll talk about that next, but the letter of intent is always helpful because that's what an attorney will use to kind of guide them through the agreement. So let's open that up now. All right. All right, I'm having difficulties. There you go, got it. All right. So this is the contract for the purchase of real estate, commercial real estate. There's always, you should always have a prepared by section noting that it's prepared by an attorney. If it's not prepared by an attorney, it's not going to be valid. We'll talk about in a minute what's called title. If there's not an attorney signature on this contract, they're not going to accept it, okay? Again, you always want it to be dated with the seller and purchaser's information and specific details that we call recitals. Recitals are always going to be where the property is situated and recorded information about the property. So for terms of this agreement, say the real estate property situated at 111 Mulberry in the city of Newark, county of Essex, state of New Jersey. You may want to include the zip code 07102, and then you always include the block and lot information. There may also be a number called a qualifier number, okay? All right, the next portion is going to be the price. Okay, what are you paying? Do you have a loan or not? And what is expected of you? How many deposits do you have to make? And ultimately, what your balance is going to be. So for this contract, we put that the purchase price is going to be $330,000. It's conditional on the purchaser obtaining a commercial loan in the amount of $234,000, which means that if the purchaser cannot obtain the commercial loan, they can get out of the deal. You'll have your deposit amount. For commercial properties, your deposit is most often going to be no less than 10%. And when it's due, and then you'll have to pay your deposit that will be due at the closing. Closing is the day that you transfer your money and you sign documents and you get your keys. Okay. All right, let's jump down to the condition of the property. Like we discussed with commercial leasing, when you're purchasing, it's even more important that you do your own due diligence as far as the condition of the property, okay? When you purchase commercial, when you're doing a commercial transaction, you're going to have fewer protections than if you were purchasing residential real estate. So that's why it's really important that you do your own due diligence. If you're using a loan, if you're taking out a mortgage on the property, your lender is also going to have an attorney to make sure that they're doing their due diligence as well, because the stakes are really high with commercial properties, okay? So when I say condition of the property, what do we mean? We mean doing your due diligence, checking the state or municipal requirements to see if there are any ordinances. You want to make sure that the property is zoned correctly. So say you're purchasing a property that's a commercial property, you want to put a store downstairs, you go to the closing, and then you get a violation because you're not using the property in the way that it should be. Then you go check the records and you find out that it's really supposed to be a 3-family home and that the address is not zoned for commercial. Now you have a problem. So you always want to consult with your attorney about that. As attorneys, we often pull what's called Oprah requests, which isn't just information that we want to get about the property, any and all information that we want to get about the property, so that we can do our due diligence. For terms of this contract, we said that the purchaser will have 30 days to conduct their due diligence. This is separate from residential real estate, where the term is likely going to be 14 days or less. All right. You also want to know if you're purchasing a commercial real estate with a tenant on it. Someone asked earlier about how to break their lease, et cetera, and we talked about the right to exhibit. You want to make sure that if there are any tenants in the property, especially in the commercial section, if it's a mixed use, you want to make sure that you have their leases on file so that you can understand whether they have the option to renew, especially if you plan on using the property yourself. Okay. All right, let's talk about title and tenancies. So title is really important. So at some point in the transaction, your attorney is going to order what's called title. So title is going to be a search of the property and a search of the parties interested. As far as real estate transactions, the parties that the title company will search are going to be your purchaser and your commercial seller. What the title company is going to look for are any debts or judgments that are against the parties. As far as title, though, the party that's most important is going to be your seller. The reason why that's important is because if any judgments come up against the seller in the title report, that means that those judgments would have attached to the property. And if say, for example, you have a mortgage, your lender is not going to finance your mortgage without that. So you need what's called clear title in order to close. We represent a lot of cash buyers. If you are doing a cash transaction for commercial, we strongly recommend that you close without clear title. You don't have to. You can agree to take on those debts, but most attorneys will recommend that you close with what's called clear title so that you're not responsible for someone else's judgments. But if you do have a lender, your lender is never going to let you close with debts and judgments on the property, okay? So title is a really important aspect of the transaction. Your attorney is going to order it. They will go over the report thoroughly with you. If you're selling if you're selling a commercial property, if you're selling a commercial property, your attorney is also going to go over the title report in depth with you because they're going to need a lot of pertinent information from those documents in order to draft what's called conveyance documents. So this is your deeds, your affidavit of title, anything that's needed to convey the property to the new purchaser. Okay. All right, escrow. Who holds it? This is another important section. So for commercial transactions, you always want your escrow agent to be your title company. Why? The reason why that is because your escrow agent, your title company is going to be a neutral party. They're not going to have any connections to either party besides the fact that your attorney, if you're purchasing, is going to be the one to hire them. But your a purchaser or a seller will not be the one to hold the escrow. You always want the title company to hold the escrow, just in case there are any delinquencies or any matters, that a neutral third party is holding the escrow. And in a commercial transaction, it always has to be a title company. Okay. Commercial zoning. So we talked a bit about this, but this is an important paragraph, and this is why attorneys separate it and we make it our own paragraph. You want to know what the property is zoned for. Okay, you want to know what the property is zoned for, and you want the seller to warrant that. So the reason why we say warrant is because we want it to be their representation. However, you also still must do your own due diligence. So for example, this real estate transaction says that the purchaser plans to use the property for mixed residential / commercial use. What that means is part of the property has tenants in it that's living, and part of it is going to be used for commercial. It's really important to understand what the property is zoned for, because time and time again, we experience transactions where a client is trying to buy a commercial property and then we find that it's not zoned for the actual use. You have a problem there because you don't want to face any violations with your municipality because you're not using the property in the right way. It's also important to note how the contract is drafted. So I always note I can always determine whether a property is zoned correctly or not, depending on the type of contract that a seller's attorney tries to give me. So if it's a contract that looks like this, then I understand that the property may be zoned for this proper use. However, if you're trying to do a commercial real estate transaction and you see that they are drafting it on what's called a standard contract of sale document, which is a document that an agent can draft, you know that the property is not zoned correctly. And then your attorney should definitely go forward with doing their own due diligence and putting an open request to make sure that it is zoned properly. Okay. Okay. Seller representation. I'm not going to read all the paragraphs, but I highlight this because it's really important. You want to know what the seller is warranting as far as the condition of the property. And it's likely going to be the case that this paragraph is going to say that the seller is not making any representations as to the condition of the property, and that the purchaser must do their own due diligence. Again, we keep using that word due diligence because purchaser is going to have less protections, but you want to still make sure that the property can be used correctly and that there aren't any problems. A seller is never going to warrant to the condition of the property, or they shouldn't warrant to the condition of the property. If they do, it's likely going to be the case that once you continue and read on, there's going to be a section that says that while this is the case, buyer must still do their own due diligence, okay? And when we say due diligence, that doesn't mean just pulling an open request, what I talked about earlier, but also getting inspections done. Due diligence may be a part of title, making sure there aren't any judgments against the property, making sure the taxes are paid, and so on and so forth, okay? And I think that's it. I glossed over a lot of the sections that aren't important for purposes of this transaction. I mean, for the purposes of this presentation, but if you're interested in commercial purchasing, you should definitely consult with an attorney who should go over each paragraph in depth. At least at our firm, that's what we do. I'm gonna jump over and see if we have any questions. All right, I don't see that there are any questions in the Q&A. Okay, I see a couple. Like residential, can I ask to have repairs done or use it as a negotiation? Both. You can definitely ask to have repairs done. So what's going to happen is during your due diligence period, you will get an inspection done. And once you get your inspection done, your inspector will produce what's called an inspection report. You'll send that to your letter to your attorney, and your attorney should draft what's called an inspection demand letter. And basically what that means is they're asking the seller to make repairs or not. When you look at your contract, you want to read to see if you're allowed to do so. Some contracts are strictly as is. So what that means is strictly as is transaction means that while you can always do your own due diligence, the seller is not going to agree to make any repairs, and that you agree to those terms. The only caveat is that if you are not satisfied with the results of the inspection, you can terminate the transaction. Okay. As part of negotiating, can I ask the seller to clear the lease spaces before closing? Yes. Yes. That's an important question. That's a really good question to ask. Depending on their lease terms, yes, you can ask that the property be delivered vacant. And that's always going to be a separate section in the commercial, in your commercial contract. And it'll be a section called tenancy, and you'll say that the property shall be delivered vacant. How long can the transaction take? It really depends. If it's a cash deal, 30 days. 30 days is the absolute minimum. But because it's a commercial transaction, it'll likely take a longer than that. The only reason why I say 30 days is the absolute minimum is because you really want to take your time with doing your due diligence. So not just pulling title. Title can take anywhere from a couple of weeks to a month to come in, but not only are you waiting to make sure your title is clear, but you really want to do your own due diligence as far as determining your zoning and also doing your inspections. And then if you have if you're financing the transaction, which means you're going to have a mortgage, that will take as long as the lender takes. Someone said, I bought a property and the seller did not tell me about damage to the building's foundation. What can you do now? You should definitely consult with an attorney about options that you may have there. But like I said, in your commercial transaction contract, there's likely a section that says that your seller is making no representations as to the condition of the property, and that the buyer shall do their own due diligence, which means that anything that was discovered through an inspection, for example, should have revealed that. And if you didn't, if you did get an inspection done and it didn't reveal that, then maybe you want to talk to your inspector about that. Okay. All right, what are the additional costs for purchasing, the buying price, attorney's fees, what else? That's also a great question. There's always going to be what's called closing costs in a real estate transaction. So your closing costs are going to include any money that you have to bring to the table as far as your deposits or down payments, your attorney's fees. Your attorney fees is going to range. Some firms charge flat fees and some firms bill. For commercial transactions, it's likely, especially depending on the size of the size of the deal, an attorney may bill because there's going to be more that's involved. And then you're going to have title fees. Title fees are always going to be on there, and your title fees are going to be a percentage of your purchase price. All right. Do I need to develop the purchase, or can I just sit on it? That's a great question. You should also contact an attorney, especially an attorney that deals with land use or redevelopment law, to see what your options are. Depending on how you're buying the space, if you're doing, say you're purchasing a vacant lot of land and you want to develop the property, if you're purchasing the property from a municipality, it's likely going to be the case. And for the purposes of this presentation, I didn't go into those details. I'm just talking about a standard commercial transaction. But if you're purchasing the property from a municipality, for example, there may be redevelopment laws around that requires you to develop the property in a certain amount of time. Okay. I'll grab a drink of water while I see if we have any other questions, but thank you so much for having me. Thank you, Invest Newark, for having me. If you have any further questions, feel free to visit us online at mileslawllc.com, or you can also follow us on social media platforms with the same handle. And yeah, we'll be happy to assist you.
Alana, thank you for your very informative presentation. We greatly appreciate it. For anyone who is interested in real estate development opportunities in Newark, please check out the Newark Land Bank at landbank.investnewark.org. On our website, you can also find information about joining our small business database, as well as information about contracting and procurement opportunities through our procurement portal. This concludes today's webinar on Small Business Law 101 Real Estate Edition. We hope that you join us for our future events. Thank you and have a great day.